also under the international legal human rights frameworks. For example, from the case law of the Inter-American Court of Human Rights, we can look at the El Mozote case and the concurring opinion of Judge Sayan there. And from the European Court of Human Rights, the example would be the Margus decision, in which the court suggested that amnesties or certain compromise solutions may be lawful, permissible, if there is a genuine reconciliation process and if reparations are provided to the victims. A positive duty to negotiate or adopt accountability mechanisms as part of a peace negotiation does not flow from this set of norms either. And even where such justice mechanisms are included in a peace agreement, there seems to be scope for different modalities and implementation strategies. For example, the strategic definitions of command responsibility can be used, or selective targeting of those most responsible may be permissible. Also, the use of alternative or criminal sanctions have been supported in some processes, and the recent ICC reactions to the Colombian peace process, the Colombian peace agreement, suggests that use of alternative sanctions can also be supported within the framework of international criminal law. Other than compromise justice, it's also suggested that sequencing can be used as a tool to balance the demands of peace and justice. A method of such sequencing would be to stay silent in the peace agreement on the issue of justice altogether and leave this issue to a more stable post-agreement phase. But this would face the most obvious risk of non-implementation in the future. The elites may never agree on justice mechanisms, and in any case, this sort of strategic silence may not convince the parties who fear accountability to sign an agreement that does not contain explicit guarantees of non-punishment. A milder sequencing method would be to opt for constructive ambiguity in the agreement by including only a generalized commitment to ensure accountability and justice in the post-agreement phase, but this would again run the risk of non-implementation in the future. So in order to see how the practice of peace agreements, whether the practice of peace agreements affirms the relevant international legal framework or any new emerging norms, and how international law has been observed in different peace processes, I looked at 63 peace agreements concluded between 1989 and 2016. This survey reveals the varying observance of international law in different processes, as well as the limits of peace agreements in terms of contributing to post-conflict justice, and especially post-conflict criminal justice. So first of all, the majority of these agreements adopt a very narrow approach to post-conflict justice, with a focus on criminal accountability for conflict-related crimes and serious violations of human rights. And these human rights are often only civil and political human rights. So these agreements overlook the issues of collective responsibility or socio-economic injustice in many cases. In line with this focus of the peace agreements, I charted the justice mechanisms that aim to deal with such abuses, which are crimes and serious human rights violations. And here what's remarkable is that blanket amnesties and de facto amnesties, by which I mean silence in the peace agreement about the justice issue, are still in use. And the most recent examples are from Ukraine and the Philippines. And also, agreements on reparation schemes, truth commissions, and trials are underused. Arrangements on these mechanisms are underused. Only 20 agreements in total use such mechanisms. Where these mechanisms are in operation, these are mostly negotiated outside the peace process. So overall, this practice reveals that many peace agreements do not make any substantive contribution to criminal justice. And where they include accountability mechanisms, these are mostly in the form of generalized commitments to future action. And lastly, these findings also support an argument that this practice does not signal an emerging customary international law duty to adopt to adopt justice mechanisms in a peace agreement. And lastly, I will briefly look at the Minsk agreements. It's been already discussed yesterday in some panels. President Poroshenko announced his peace plan in 2014. And in this peace plan, there was an amnesty clause, but it was a limited amnesty clause. At first, it excluded grave crimes and crimes of financing terrorism, but the last part of that sentence was later dropped, so it only excluded grave crimes. But when the Minsk agreements were signed, both of them included a blanket amnesty provision. These agreements have been endorsed both by the ICJ and the Security Council. In the Security Council debate, representatives of two states expressed their concerns about the scope of this amnesty clause because they thought it might lead to impunity for the MH17 incident. But if we look at the text of the resolution, the resolution does not express any concern about the scope of the amnesty. But ever since the signing of the agreement, the Ukrainian side interpreted this provision as a limited amnesty clause, whereas the other side insisted on the textual interpretation and claimed that this was a blanket amnesty. This is in line with the general practice of peace agreements. So, can there be any guidelines or any lessons learned from the past practices in order to move forward with a new peace agreement, a more comprehensive peace agreement in Ukraine? It's difficult to draw lessons from the past practices in terms of the mechanisms that are going to be used in a different context. We heard about this in the previous lecture. But there seems to be two broad lessons learned. The first one is the need to adopt a long-term justice policy that goes beyond the peace negotiations and the peace process and their outcome peace agreements. And the second is to create the channels that would allow the development of domestically embraced justice and reconciliation policies that provide for criminal justice, but also for other types of justice. And I'll leave it here. Thank you very much.
Thank you, Osli. Thank you for your interesting presentation, and thank you for drawing our attention not only to general issues of post-conflict settlement, but also to particular issues, for example, such as amnesty clauses. Yesterday we have discussed these clauses of Minsk agreement in particular, and there are a lot of misunderstanding of such clauses, as you have pointed out. Surely, while speaking about compromise justice, it is needed to maintain a balance between state commitments before international law and needs of reconciliation. Surely, in international law doesn't recognize any amnesty as to serious human rights violations, as to serious crimes. And Minsk agreements also provides amnesty, but only to minor offenses, and all serious crimes should be punished under international law and under municipal law, municipal legal systems. Also, in number of its judgments, European Court of Human Rights, I would refer to European Court once more. In number of its judgments, European Court has affirmed that granting amnesty to killing of people, to killing of civilians, and even to ill treatment of civilians is contrary to state obligations under European Convention. So it is essential to draw attention and to pay attention to maintaining of this balance between state commitments and between international law and need of reconciliations. Also, thank you for shifting such a topic as post-conflict regulation, this jus post bellum, as it called. It was actualized during all peacekeeping processes, and I think that here it is important to stress on this shift. It's a shift from security, political, and military aims of each conflict to aims to maintain needs of civil society, people, and human rights. And indeed, when we speak about any armed conflict and any atrocities of war, first of all, we think about that is human being, that is people, their needs, their lives, their destiny. But also there is another huge part of our life which is not less important. This is need for healthy environment, common heritage of mankind and its preservation during the war, and including cultural property. And now I shall give the floor to Katerina Busel, and she will study accountability for international humanitarian law violations from the lenses of cultural property. Katerina Busel is a representative of the Ukrainian International Law Association, and she is member of Cambridge Society of Ukraine and Vice President of International Council of Museums. So, floor is yours.
Thank you, Olga Volodymyrivna. Just to correct, I'm not a Vice President of the ICOM. I'm just a member of ICOM, but Vice President of the Cambridge Society of Ukraine. But my research that I present today is connected with my legal practice in Ukraine. I work as a legal associate for Global Rights Compliance. This is a British legal firm that consults Ukrainian state authorities and civil society on ICHAM implementation and investigation, prosecution of international crimes. I kindly draw your attention to the picture used as a backdrop for the presentation because it's guiding for the logic of the presentation. So at first sight it might seem that I use the Ukrainian flag and you will think, well, just a silly patriotic girl just put in a flag on the presentation, but if you took a closer look, you see a landscape with a quite wide horizon line, and you can see some sheep or and a small house over there. So my concept of this picture as used for my presentation is that indeed the presentation is about accountability, but I'm using a wider approach, and I will speak more about the implementation of international humanitarian law in Ukraine in 3 sectors and how this implementation influences the accountability. So the principal 3 sectors I will address in the presentation are through the lenses of cultural property. First, the failure of Ukraine to take all domestic implementation measures that allow my country to trigger all available international law measures, and I will use cultural property as an example. Then I will speak about the legal training on international humanitarian law of specialized officers such as the military and the prosecution, and also of the legal background of the civil society. And third, I will speak about the highly covered topic of the domestic implementation of international criminal law in Ukraine and how it fosters the accountability for IHL violations and how these 3 fields have changed since the 2014 and 13 events. So, as regards the first issue, the failure to implement all domestic measures that help us use all the available international law measures. There's a huge debate in Ukraine that we should ratify the 2nd protocol to the Hague Convention for the Protection of Cultural Property in the event of armed conflict, so that it will save our cultural property in Crimea because it criminalizes the archaeological works in an occupied territory. But what our state authorities sometimes fail to note is that the enhanced protection granted by the 2nd protocol is provided only to those objects which receive proper protection domestically. So if Ukraine fails to prove that it allows and protects fully its cultural property under its domestic law, it cannot require an enhanced protection for these objects. And I just used a couple of examples to show you that we don't protect properly our cultural property domestically. We don't have an all-encompassing inventory of cultural property of Ukraine. So we do have just one inventory, not one, but one important inventory lists all the super important cultural objects of Ukraine, but there are others as well, and they are not on the list. We don't have the proper concrete GPS coordinates of all the cultural objects around Ukraine. And my colleague Dmitro Koval and Helsinki did a research last year saying that many objects need this GPS indication on the maps, because as you imagine, the armed forces, when they are in the hostilities, they need precise coordinates to decide how to launch an attack. And you understand that GPS coordinates are crucial for complying with the principle of distinction in IHL, and this is something that our army is stripped of, unfortunately. Also, the looting cases. You probably have heard many allegations of looting of museums in Donbass, and the funny thing is that the management of museums say that this is the armed groups that loot the museums. But there are also the reports that some museum staff are involved in looting or, illicit trade in those museum activities. And why such allegations are possible? Because neither the artworks nor indeed the registers of the museums in Ukraine are not properly digitalized. So we don't have an electronic Word document saying what property what museum has. And as you understand, it provides a huge room for manipulation, unfortunately. So I am supportive of the ratification of the second protocol of the Hague Convention, but I'm also demanding that the government takes proactive steps in implementing all related IHL implementation activities domestically. Turning to the issue of education, dissemination of IHL knowledge, there are 3 points I would like to stop on. The IHL background of the military, the education of the society on IHL, and the concept of IHL in contemporary art and how challenging it is for our army, for the Ukrainian army to comply with. Well, first, starting with the legal background of the military, we do have quite an old so-called military manual that lists all the requirements for the training of the Ukrainian armed forces. As Professor Gontovsky noted today, many rules outdated, many rules were omitted, many sections were mixed and intermingled, and I'm very happy to say that the Ukrainian authorities were open enough to external consultancy, and the new military manual, or an updated version of the military manual, has been drafted. It's soon to be approved finally, or it's in the final stages of the approval, and it will provide a more comprehensive procedure program for the Ukrainian army to comply with as regards IHL. I also consulted the German and American colleagues, and they said that it's crucial for us to ensure that every serviceman has a portable and easily readable manual, sort of a mini version of the manual for them to consult on the basics of IHL when they're in the hostilities. So this has also been worked upon, but it was not the case before. And I'm happy also that the Minister of Defense adopted a new order on its legal service in 2016, where it reforms its legal department, and it enhances the monitoring missions of the lawyers who specialize in IHL, and the order also enhances the recommendations and the strength of the recommendations of lawyers who can give these recommendations to the military. But also what's necessary is to make clear the procedure of how the different members of the Ukrainian army pass the IHL exams, what happens if they don't pass, whether it's crucial for their promotion within the army. As far as I have seen, and not documents are public, we don't have this clear procedure, and it should be clear. At least within the Germany, again, they condition the promotion within the army on the successful passage of IHL training, and this is something crucial that we should also have in Ukraine. And also, what is important is to have specialized trainings for the army say, on cultural property issues, on sexual violence in an armed conflict. And that is something that hasn't happened in Ukraine before, but the Ukrainian authorities, different parts, not only the army but the security service, they're gradually opening their gates to external consultancy on these specific armed conflict-related topics. As regards the society, I concentrated on looking at the school curricula on law, and I can say that unfortunately our kids don't get any understanding of what's going on in their law classes at secondary schools. So basically it's just only the basics of the Constitution of Ukraine and the basics of the human rights, like the Declaration of Human Rights, but the kids who live in a country which is suffering from two armed conflict, unfortunately, are being not informed of what's going on in legal terms. It is being corrected a bit in high school, because then the topics of IDPs, refugees, times of emergency are being addressed, but there are also many problems with that, because firstly the issue of indigenous peoples are not addressed, and these armed conflicts in Ukraine have shown that we paid not enough attention to these issues. Secondly, such issues that were developed in a way in practice, like the participation of females in the army, in the Ukrainian army, again, they are not addressed in the school curricula. So I think where we have an option or an opportunity to make the education more progressive, we should do that. So I think, yeah, the society that receives the basic information about law and about the legal regulation of the armed conflict at school, it's not well prepared, and I'm happy to say that at least Amnesty International in Ukraine does cooperate with the Ministry of Education to update our law curricula so that they represent the reality of what's going on, and that these curricula really inform the kids about the ongoing armed conflicts and what's happening, who are IDPs, and how we should react to them. And also, cultural property in Ukraine has shown that there is a huge problem with protecting contemporary art in armed conflict. There is a case of Izolyatia. I think the majority of people, of Ukrainians, know that this is a contemporary art center in Donetsk. It was occupied by the militia of the Donetsk People's Republic, and they turned it into a detention center, surely destroying all the archives, all the artworks, and basically they just took over the art center. And when I discussed this case, both with the Ukrainian military and with the Ukrainian residents of Donbass, they said, well, yes, it is a clear-cut war crime. We understand that taking cultural property, turning it into an object of attack, is prohibited under international law. But like ordinary people, especially in Ukraine, which is not keen on contemporary art, they would not understand that they come into a building, they see a bunch of metal, and this is an artwork to protect. So the case of Izolyatia of a contemporary art center in Ukraine has reassured me that we have to have more expanded and interdisciplinary trainings, even in IHL implementation, because, you know, cultural property is not just a classical work of art, but it indeed can be a bunch of metal, and it's something that neither our military nor our civil, like the wide range of the civil society, are not taught. The final thing is the criminalization of war crimes. I absolutely support Professor Bosensioni, who yesterday, and Gleb Bogush and Professor Bogush and Professor Kantovsky today said that the domestication of international crimes is important, because international courts and the ICC will not do the work that the domestic courts should do. And the Ukrainian provision on war crimes is just one, all-encompassing Article 438 of the Criminal Code of Ukraine. It doesn't list all the war crimes, or neither the great breaches of the Geneva Conventions. It mixes the international armed conflict and non-international armed conflict crimes, and the article is mostly focused on international armed conflict crimes. The crime of misuse of a cultural property emblem is not criminalized in Ukraine. And I can say that I double-check our state registry of court decisions, and there are 44 proceedings that refer to Article 438, the war crime article, but there are no convictions, as it has already been mentioned today. And the judges in these decisions that concern mostly the investigation activities as of now, they usually mix the human rights violation, the terrorism counts, and some war crimes cases. War crimes examples like just the violation of customs and rule of warfare without specifying what particular violation it is. And they tend to focus just on the crime of terrorism. And as we mentioned today, it's problematic when we have a soldier, you know, a lower ranking military who's being prosecuted for terrorism or for a crime of aggression. And we see that this is a very uneven path for Ukraine to take. It was I think, reaffirmed in The Hague during the Ukraine versus Russia cases that we cannot claim that all the violations in Donbass are terrorist attacks. So, I looked at the criminal codes of former Soviet states, namely Georgia, Baltic states, Moldova, and I also looked at the criminal codes of some post-Yugoslavia states. And I can say that although, especially the Baltic states, they haven't had an armed conflict, but their provisions on war crimes in general and on the war crimes dealing with cultural property in particular are much more detailed than the Ukrainian code. So they codify, as regards the cultural property, the behavior that makes artwork, cultural property, an object of attack, the unlawful destruction of cultural property, the destruction that is not justified by the military exigencies of the situation, the looting, and so on and so forth. So the provisions are very detailed. Again, the UK has recently adopted a Cultural Property in Armed Conflict Act because it ratifies the Hague Convention. And this is a very detailed text that specifies the notions of common responsibility, the notions of jurisdictions, and the notions of particular levels of responsibility for different crimes. So the proposal to properly codify international crimes in a country that is suffering from two armed conflicts is not new, and indeed the states that are at peace at the moment do have more elaborate provisions. And to wrap it up, I would like to say that I don't idealize Ukraine, and I don't claim that we were ready for this armed conflict, both in terms of law and in terms of military capacity. But I think we should take the armed conflict as a chance, as a catalyzing effect to make the respective changes in the legislation and to maintain this social, civil society and state cooperation which is there at the moment. Because as I told you, such institutions as the Ministry of Interior, as the Armed Forces of Ukraine, as the Security Service of Ukraine, they have never been so open to external consultancy the way they are now. And I hope this cooperation continues in times of peace. Thank you.
Thank you very much, Katerina. Thank you very much. Thank you very much for stressing on the failure of Ukraine to implement properly norms of international humanitarian law, especially as to cultural property. And let me add, I think that you will agree with me that we have the very same problem, not only with so-called national treasure as it is named in Ukrainian legislature, but also with property of Academy of Sciences of Ukraine, which has left unoccupied territories and which consists of unique species, unique scientific property, unique scientific materials and results of inventions and investigations of our scientists. So we also shall need such a registry as the registry of cultural property. So today, I think I see that we are going from some general issues, such as post-conflict settlement, to more specific points, as cultural property and its protection during an armed conflict. And now there is another quite special issue, quite special subject, that is illegal detentions and forced labor in the area of armed conflict. And I would like to give the floor to Nadia Volkova. She is representative of Ukrainian Helsinki Human Rights Union. Please, the floor is yours.
Thank you very much. It's just this particular offense is just a side note. I'm going to just give you the context. It's not going to be just about. It's going to be my presentation is going to be generally about the investigations, the level of the importance and the meaning of the investigations as a prevention to the spread of impunity. We all understand that investigation of the crimes against humanity and war crimes is not only a key element, but rather a prerequisite element of transitional justice. And without effective investigation, and the effective is being an operative word here, any other crime simply any of the crimes, simply no justice can be done, and lack of effective investigation is a root cause of the impunity, and sadly this is the picture in today's Ukraine when it comes to investigating conflict events, equally in Crimea and the east of Ukraine. The focus of my presentation is going to be on the investigations in respect of the crimes committed during the conflict in the east of Ukraine. And therefore, the way I've structured my presentation is, firstly, I'm going to speak about the meaning of effective investigation and the consequences of impunity. Then I will briefly talk about the two reports that my organization released in the past 2 years on the investigation of the crimes committed in the ATO zone, and I will briefly explain the shortcomings of the currently pending investigations and their root causes before the state authorities, and I will conclude by expressing my personal view on the needs and what needs to be done in order to start changing the situation we find ourselves in. If we look at the transitional justice as one of the means towards transformation, reconsideration that facilitates learning of the lessons, investigation is about establishing facts which prove that something that needs to be transformed has taken place. It builds a real picture of what has actually happened and not just someone's subjective interpretation. And so this is very important. Therefore, we can all appreciate and never ever underestimate the importance of effective investigation, especially when it comes to war crimes and crimes against humanity. Because the investigations of the crimes on such a scale is a process of transformation for a multi-million nation and beyond. From our point of view, Ukraine is struggling enormously with grasping the critical importance of effective investigations of the crimes committed in the course of the armed conflict. It is indeed a frightening prospect, because this means that our nation is risking not only to learn its lessons, but it failed to understand why this has happened to us, come to terms and reconcile with the fact that it has happened to us, and get the answer to the ultimate questions, what it is that we must or must not do and how to behave in order not to find ourselves in such a predicament again. It's all very well to say that it's Russian fault, it's the fault of the Russian proxies, but we must not forget that Ukraine is a party to this conflict, and we must not alleviate ourselves of the responsibilities as a party to the conflict. In other words, we are risking not only to fail to grow as a nation, but our survival as a nation becomes a moot point. In the past 2 years, we have released 2 reports. One is called Total Impunity in the ATO Zone, Investigation into Killings and Disappearances, is dated October 2015, and the second report is also Total Impunity 2, Investigations into Illegal Detentions and Forced Labor. It is the latest report. It was released at the end of 2016, so the information here is more up to date. That's why it's the context. I've chosen the final report for the context of my presentation. So the conclusions that we've drawn as to the quality of the investigations were based on the real cases that we have been working on since the beginning of the conflict in 2014. We've built a case base of around 200 cases. They are currently pending, practically all of them pending before the European Court of Human Rights. 100% of the cases raise a violation of the procedural limb of the Articles 2 or 3 of the European Convention on Human Rights. If we talk in domestic level terms, this means that in 3 years, from the beginning of the conflict, none of the offenses have been investigated effectively, which means that the state authorities failed to establish the facts of the violations, identify the victims, establish the perpetrators, and this whole process has not resulted in the accountability of anyone. It is not just one reason for such failure on the part of the competent state authorities. The problems lie in the lack of experience to investigate such complex crimes, the lack of appropriate legislation more generally, and the absence of suitable legislative framework. But most importantly, I think it also lies in the mindset of those responsible for ensuring that these crimes are investigated. They seem to fail to understand the importance and, well, they fail to feel responsible, therefore. Currently, we have 130 people, civilians, both civilians and military, who are still being illegally detained on the territory of L and DPR. Some of them have been in this illegal detention for about or more 3 years. Majority of the relatives have obviously gone to the investigating authorities, and the investigations are pending on domestic level. In the case of domestic level, pending means that the investigation has been opened, but there has been, well, or practically has not been any investigative actions undertaken by the competent authorities apart from registering the complaint. For instance, a wife whose husband was detained in 2014 by the insurgents and was tortured to death by them in detention as of August 2016, had yet to be granted a status of a victim and questioned as a victim or as a witness in this case. Witnesses are not identified and questions. We had a situation where 3 of the cases have been communicated by the European Court of Human Rights, and when we received their case files, we were astonished to find that was in the first part of 2016, and the complaints were registered in June to August 2014. We found no information whatsoever as to what investigative steps have been taken. We found no witnesses were identified. So we had to conduct, literally, our NGO had to conduct our own investigation, find witnesses, question them, record their statements, and because there was literally nothing to send to the European Court. So this is a widespread picture. It's just safe to say that the legal detention and torture of these people is not being investigated, obviously, with the standards identified by the ECHR jurisprudence, nor it is being investigated in accordance with the international criminal law standards. But the domestic standards, as we found, they entirely inadequate for this. For these crimes committed during the course of the conflict with the Russian Federation and its proxies. What we found, the picture across all these offenses, is that the investigations are opened under the articles on violation of the laws and customs of war, murder of 2 or more persons, terrorist attack, creation of terrorist organization, and kidnapping. As you can tell, there is an obvious problem with the first one, because legally there is no war, so that article cannot be applied. Whatever is happening in the east of Ukraine, the state has failed to qualify legally as an armed conflict, despite the fact that it has already been qualified as such by the ICRC, and it has been given a preliminary qualification as such by the prosecutor of the ICC. Furthermore, until today, the Ukrainian state has not worked out a state policy or a strategy as to how to return its citizens that are being held in detention. These people are not given a status, and official legal status, and have not been recognized as anything like prisoners of war or detainees or hostages in accordance with the Geneva Conventions. For the moment, the impression that is being given by the state of Ukraine by failing to admit and call the conflict for what it is simply trying to evade its responsibility. I mean, maybe we can discuss this later, and maybe you can see other reasons for not taking all these prerequisite crucial steps. But for the moment, to me, it seems like it's a simple evasion of responsibility on the part of the state party to a conflict. If we talk about the rest of the qualifying articles, they all have the same problem. After initial investigative actions, the investigators hit the wall in the form of inability to access the location of the crime due to the places of the offenses being under the control of Russian proxies. As far as we are aware, there have been no attempts made to actually establish a dialogue with the enemy side to, for example, locate the bodies of those who are considered to be disappeared without trace, or to get to witnesses who are still on the territory that is not under control of Ukraine. So, I mean, that's also, in my mind, a failure on the part of the state and state authorities to actually facilitate the investigation in that way. So I just would like to read a few extracts of the accounts of those who survived the detention, and just to demonstrate what is not being investigated. They are the extracts from the report. I remember quite well someone offered to castrate me. They began to take my pants off. Then, having changed their minds, they decided to cut my leg off. They buried the knife into my leg so deep, apparently trying to cut it off. I blacked out. That's another account. After being severely beaten, I could not move on my own. Did not feel my legs up to the pelvis. They damaged my pelvis and spine and ribs and head. I turned to see my leg. Then I counted 52 wounds inflicted by a club on one knee. The entire floor within 2 meters was covered with blood. Every part of my body was beaten. They broke my arm, the left hand, 2 fingers on my left hand. That had suffered the most, as when they finished bulging, I was lying on my right side and the left hand was at the top. They sent for our guys to the basement and took my clothes and brought me in. I was beaten within an inch of my life. I'm just going to probably get to another crime or offense that has not been investigated. Is the crime of forced labor. As regards forced labor, the situation is even sadder because this offense is mentioned in the article of the Criminal Code of Ukraine on the violation of laws and customs of war. Again, but it's mentioned within as part of the inhuman treatment. Well, I have already explained the limitations with this article, and it still applies here. So there's no separate offense of forced labor, and there are no investigation that has been opened into this offense. To conclude, it is obvious that Ukrainian legislation is out of date and seriously lagging behind today's needs and demands. And at the moment, it all seems like a snowball that is very quickly stirring into an avalanche. One could say that obviously Ukraine is inexperienced, and we are facing the enormous challenge, but I don't think it should be an excuse to wholly shy away from our responsibilities. I think that Ukraine needs what Ukraine needs to do now is to embrace the predicament it has found itself in by starting to take a proactive stance and concentrate its efforts on saving itself. And we have all the means necessary, and I do believe that it is a question of right mindset. We have an enormous support of the international community, but unless we actually start taking a proactive stance, this support is not going to be very relevant. Thank you very much.
Thank you very much, Nadia. And now we have some time for questions, answers, maybe some remarks, but I'm asking you to be brief and no more than 1 minute for remarks if you have it, and I'm going to you. Please introduce yourself.
Thank you. Irina from the University of Copenhagen. I have a few questions. Such an interesting panel. Thank you. And great insightful comments. Really appreciate it. The first question is very general, and it's addressed to all of you. So why do you think Minsk agreements don't work? And I know it's a big question, but maybe you can highlight the most important aspects why Minsk agreements don't work. And do you think there is a chance that we can revive Minsk agreements, or are we in need of Minsk III? The second question is directed more to Katerina. It was very interesting. I learned a lot about the protection of cultural property in Ukraine. Obviously didn't know anything about the subject. And you highlighted the importance of educating the members of the armed forces. They need to receive the proper child training. But then when we read the reports of international organizations, we can see that many indiscriminate attacks, they happen because Ukraine armed forces as well as rebel forces, they use weapons that cannot distinguish accurately between the military and civilian objects. So my point is that no amount of child training can compensate for the use of indiscriminate weapons that cannot accurately distinguish between the civilian and military objects, and what can the government do to actually avoid such attacks from taking place. And the third question is to Nadia. As you know, we have the unified register of Maidan crimes, but unfortunately crimes that take place in eastern Ukraine are not classified. We don't have any public information. There are some press releases on the websites of various law enforcement units in Ukraine. So do you think it would be beneficial if, similar to the unified register of Maidan crimes, you would have the same register for the crimes taking place in eastern Ukraine, so the important evidence and maybe the correct qualifications is not being lost if in future we have some cases being heard before the ICC or national courts? Thank you.
Okay, thank you very much for the questions. I'm going to take obviously the first and the third one, yeah. Right, with the first one, is the question of a lifetime at the moment, to be honest. So we have been actually searching for answers ourselves as an NGO or as a coalition of the NGOs, why it is that Minsk agreements do not work, especially in the part where it comes to releasing our Ukrainian citizens being held on the occupied territories and in Russian Federation. The solution that we've, the two problems that we found with the release is there is a clause that says the release of the captives is dependent upon the withdrawal of all the heavy weaponry within the delineation line, which is a big problem, obviously, because we cannot control. As a state party, we cannot have any control over this security issue. But the fact that release of the people is tied to this clause is actually quite appalling in our view, because it shouldn't be like that. I mean, they are the lives of people, and they should be a priority and not dependent upon some other conditions. So we've come up with the concept for the state strategy, how these people's release should be negotiated, and our proposal is to separate humanitarian grounds and humanitarian aspects from political ones. And perhaps that could be a solution. I don't know whether there is, Minsk 3 is going to change anything. I think we just need to start to realize that we have responsibilities, and we need to do everything in our power to actually fulfill those responsibilities, and then maybe then there will be a bit of a progress. As to the unified register of the crimes, I guess the main problem is that, there's no system, obviously, in place. It's a huge problem. And I think the underlying problem is even worse than that, because there is no system of controlling the flow of information that comes from state authorities. Just work chaotically. They don't have any system in place where they can control what information comes to them and how they can use it, and and there's no feedback and there's no report. And perhaps once we have something similar to maybe what you are suggesting, or you're talking about, perhaps it'd be easier to see what we already have and how. And it would also be important for us as NGOs to be part of the process, because a lot of people are scared to go to the state authorities, and they rather come to us and for help. So we also can enhance this process somehow. But obviously that would happen if only they listen to us. But they don't, unfortunately, so that's the problem.
Thank you. As regards Minsk, to me, the major problem here is the social attitude to the concept of Minsk. This is very negative in Ukraine. But on the other hand, I saw that our international partners are really demanding of compliance, and they say, if you don't like it, just propose an alternative. So I think in such a situation, we should better stick with what we have and try to comply. But as you probably saw from my presentation, I see the reconciliation very widely, and to me, more working with the society and trying to reconcile the society is something I would concentrate on, instead of having another Minsk that is not accepted by the people. Sorry for the vague answer, but it's something that I'm trying to do, the small steps, rather with student communities or my fellows from the civil society, instead of grand political ideas. As regards the weaponry, I can only agree with you if it's the weapon that is violating the IHL rules of distinction. Surely it's not an excuse. But to me, this issue takes us to the problem of common responsibility and the problem of not complying with the command of a senior military official. Unfortunately, as I saw, we are still a highly post-Soviet country with the post-Soviet traditions, and it's very hard for a lower-ranking serviceman to say that I will not comply. And that's why I think the training in IHL and explaining the practice of other states of not compliance with orders that are illegal is important for our officials. And I really like, again, the position of the German Minister of Defense, who say that our soldiers understand that law is their protection. That is why they're willing to know it, and that's why they know when they can say that they don't comply with an order. And this is something that I would like to, to plant into our military. Thank you.
Well, as an outsider, my knowledge of the Ukrainian peace process is very limited. But I can say a few things about the success of a peace agreement in general, which depends on various factors. But the two most important factors are whether the elites in a state have the political willingness to implement an agreement and to honor the commitments that are in that agreement. And the second thing is, of course, what Katerina said, the societal willingness, the societal acceptance of a peace agreement. So even if you have the perfectly designed peace agreement that provides for full accountability, that puts in place the perfect power sharing and decentralization mechanism, it's not going to work if there is no elite support and societal support. So I can't know whether a Minsk 3 is possible, but I can say that it wouldn't work unless it has the support of the elites and the society.
Thank you. Another question, please.
My name is Olga. I'm from Women's International League for Peace and Freedom. And thank you very much for those presentations, and especially thanks to Nadia, who raised very important issue of lack of effective investigation. In Ukraine, we have three branches of law enforcement authorities: the National Police, the General Prosecutor's Office, and the State Security Service. And two of these agencies are in the state of deep reforming, and there is really lack of coordination between those bodies. And what they are doing, they are just shifting responsibilities from one to another. It is very important that NGOs are taking part and effectively trying to document all these crimes, but this is not enough for further proceeding in terms of international criminal justice. And that is what was said by our, for example, Bosnian colleagues and Bosnian experts. That's why I have a question. Maybe Ukraine Helsinki group was talking with donors and thinking about asking for some donors' assistance to creating an agency which will be helping to collect information on the crimes committed, both on destroyed property and both on the people who were in the place of illegal detainees, because this is very important for further proceedings.
Thank you. That could be one solution to the problem. But what we're trying to do now is to actually establish a dialogue with the state authorities domestically, because we realize, we've been struck dumb with all this conflict in the city, and we have to find quick solutions to the problems that just do not have those quick solutions, unfortunately. And we need to, at the moment, we need to work with what we have. And what we have is, we have defunct, or practically defunct, investigating bodies. And I think it's our duty, if we have, each of us has a little bit more experience or knowledge that can be shared, how to solve this situation, we should do it. We should transmit it, we should transfer it, we should apply it, and we should establish a dialogue. And that's what we're trying to do with the Office of the Prosecutor. That's what we, probably will be trying with National Police. It's more difficult at the moment. But actually, and perhaps people like GRC, Global Rights Compliance, which Katarina represents here, they're doing a great job in training our authorities in documenting crimes and on the foundations of the international humanitarian law. So this is the kind of action I think that is going to be more beneficial at this point, because in my mind, establishing a new agency is going to be a long process, and I'm not sure what's going to be quicker and easier, to actually achieve our goals at the moment. Thank you.
Thank you, Nadia. Any other questions? So please.
Thank you very much. My name is Alexei, and I'm a Fulbright visiting researcher with the Cordova School of Law in New York. And my question is mostly for Ashley. Well, please forgive me if I mispronounce that. No, it's okay. But possibly I would also appreciate the comments by all the other speakers. And it appeared to me that there was a consensus in the panel that implementation of the peace process requires consensus with the civil society. But possibly, this is just kind of my comment. Maybe you could comment on that. Maybe you admit the willingness of the other party of the conflict, which I have not heard from anyone. And the other party of the conflict is, in fact, the Russian Federation. And although it would be enormously hard, possibly, to establish the chain of command and to demonstrate with any legal certainty that the Donetsk People Republic, quote-unquote, and Luhansk People Republic, quote-unquote, are supported by the Russian Federation, and the Russian Federation is responsible for their actions. But with the implementation of the peace process, is it possible to anyhow influence the position of the Russian Federation and taking the examples of Minsk I and Minsk II, I think that both parties, which are here in effect, Ukraine and Russian Federation, claim that they did everything to comply with the agreement and the other party has failed to do this. So, can you please comment? Thank you.
Thank you very much. Who would like to start?
Thank you very much. Well, of course, when we talk about the elite support, the elite political willingness to implement a peace agreement, this includes all the actors that are involved in an armed conflict. If it's even if this is an internal armed conflict, if there is international involvement in the conflict, this would also require the support of this international actor interfering in this conflict, the support of this actor to the peace process as well. So obviously the civil society in this party should be willing to support the peace agreement. And
with the other party, you mean?
Russia,
Yeah.
yeah. Yes, of course. And that's why Russia is an actor in the peace process. But one of the features of the Minsk process is that Russia is not understood as a party to the conflict. It acts more as a facilitator, as a mediator. So that's one of the, you might say, problematic side of the Minsk process. So, of course, Russia has to support the implementation of the peace agreement as well if it's going to work.
Thank you, Asli. Any other questions? Yeah.
Hi, Valentina Polunina, Munich University. I have a very brief question to Nadia Volkova. I'm wondering if you have any information about people being illegally detained in the ATO zone by the Ukrainian military forces.
Yeah, thank you. Yeah, well, we've had cases in our practice where we represented people who were illegally detained and tortured by the Ukrainian state authorities, of course. Not in those numbers as the other side, but there are quite a few of them. And as to our information, and I think everybody's read those reports, or but at least some, people who are kind of interested in this subject matter about the SBU secret prisons. So yeah, we have some clients from there, and we know about those cases, but the numbers are disproportionate to our knowledge. We might be wrong, but that's what we know.
Thank you, Nadia, and we have time for one more question, please.
Hello, I'm John Cubban from the EU Advisory Mission. My question has been sparked off by something that Asli said, but it's probably something that all of the panel would like to comment on. We've heard a lot in this conference about the obstacles to effective post-conflict justice, but there was one thing that Asli said, which was that the last few years have seen increased legalization and internationalization of post-conflict justice and peace negotiations. I think that probably gives one grounds for hope in the long term, and I'd just like to hear the panel's reaction to that, whether this is a positive development, and if so, why, and how they see it in the future. Thank you.
Thank you very much for a great question. Well, yes, there has been a trend of legalization and internationalization in this area since the end of the Cold War. This might be a positive development if you think about the norms that aim to broaden participation in peace processes, that aim to include issues other than the narrow interests of the conflict parties into the peace process. But it also depends on how these international legal norms are used. For example, if you look at the Colombian example, Albie Sachs also talked about this example in his lecture. There, the Human Rights Watch opposed the peace agreement all on the basis of international legal arguments, because they adopted a different interpretation of the international legal obligations to prosecute and the individual human rights of the victims. On the other hand, you had the government and the armed group who were willing to commit to certain justice mechanisms, which were a mixture of limited amnesties, truth commissions, criminal prosecutions and alternative sanctions. They also adopted different interpretations of the legal norms. That's why I think legal clarity in this area and having consensus, some sort of consensus about the scope of the legal norms is incredibly important, because these norms can be used for both purposes. Also about the process, about broadening participation. If you rely on the principle of self-determination, on the principle of gender inclusion in peace processes, you would broaden inclusion in a peace process. But if you rely on a purported norm of exclusion of perpetrators of international crimes from a peace process, then you wouldn't have the relevant actors that you should be negotiating with in a peace process. So it is, I think, incredibly important to have legal clarity, and that's why I mentioned this specific example from the 2012 UN guidance for effective mediation, because there they are making this distinction between binding legal obligations and normative expectations. And if you're talking about normative expectations, I do not want to use the term compromise now, because Albus Sachs suggested a better term. Then you can have space for accommodation of different interests as well.
Thank you very much. So we are in time now. I'm grateful to all speakers of our panel. I'm grateful for your interesting surveys. We have revealed different topics and different aspects of accountability for IHL violations. Maybe there are some ideas which we can stress on. Not all violations of international humanitarian law are the same as crimes against humanity or war crimes. International humanitarian law is much wider, and now it was shown by our participants. And another thing, I'm also thankful for our speakers and for all participants in our discussion. We have another problem. It's more wide than just absence of these or that rules in criminal code of Ukraine, or these or that rules on responsibility for IHL violations. The problem that we have is the problem of deficiencies of whole Ukrainian legislature on international law. The place of international treaties, its norms, its rules, the place of international law is not defined actually in our legislature. So the problem is more systemic and more huge. I'm grateful for everybody, and have a nice coffee break. Thank you.
We are starting the closing session of this conference. Time really flies. We might be able to wrap up slightly ahead of our schedule, because everyone seems to be a little bit tired, and we are likely to hear much more interesting things, except for this immediate part of the session, that is the briefing on workshops and the conclusions from the workshops. And here we have the moderators for the 6 workshops that we have had yesterday and today, with actually 2 substitutions. Judge Turkovic had to leave us a bit earlier, and therefore we have invited Professor Tatiana Ansupova, who was part of that panel, number 3, workshop number 3, to debrief us on that workshop. And also yesterday there was a replacement of the moderator for workshop 4, as our host, Mr. Bushenko, had a very, very important appointment. Therefore, Professor Sayapin has kindly agreed to replace him, and therefore Professor Sayapin will also report on workshop number 4. I would ask the moderators and rapporteurs to limit their feedback to 5 minutes, if possible. If you can make it even quicker, that's also fine, but it's up to you. Okay, so we'll start with workshop 1, the workshop that took place yesterday. Professor Bolsh.
Thank you. Workshop number one. Actually, it's I don't know whether it was a deliberate decision of the organizers to put this topic as a first topic. But the workshop was dedicated to the role of the International Criminal Court in the post-conflict settlement in Ukraine. We had four presentations, four presenters, and it happened that they looked at the problem of the international criminal justice and the role in the post-conflict settlements from the totally different angles. There was two, I would say, legal and even legalistic. I use the word that was used by the speakers themselves. Presentations, and two presentations that was more kind of philosophical or sociological outlook at the international criminal justice. The first presentation by Irina Marchuk concerned the jurisdictional and legal framework of the possible ICC investigation and intervention in the Ukrainian situation, Ukrainian conflict. To discuss in particular the validity and legal problems arising from the first Ukrainian declaration of the acceptance of the ICC jurisdiction concerning the events in Kiev and Maidan, and also the